The period following the Civil War was marked by shocking abuses of individual rights and by a constitutional amendment, the 14th Amendment, designed to halt those abuses. The seeds of those events were contained in our founding documents, including the Declaration of Independence. By the time Congress convened in 1866, anti-slavery Republicans dominated both houses. Led by men like John Bingham in the House, along with Senators Charles Sumner and Jacob Howard, radical Republicans enjoyed complete control of Congress.
They have the power to amend the Constitution, and they are determined to use it. They were faced with an unending series of abuses in the Reconstruction South. State and local governments had responded to the new 13th Amendment ban on slavery by trying to deprive newly freed slaves and their white supporters of any meaningful freedom, especially economic freedom.
The 14th Amendment was proposed in response to this wholesale violation of civil rights, as embodied, for example, in the notorious Black Codes. The architect of the 14th Amendment, John Bingham, was a learned and well-respected lawyer from Ohio.
John Bingham believed there was a hole in the original Constitution, which was that it didn't give the federal government the power to protect individual rights from interference by the states. The 14th Amendment was Bingham's effort to fix that.
The 14th Amendment protects three distinct interests: due process, equal protection, and the privileges or immunities, meaning rights, of United States citizens.
Senator Jacob Howard worked very closely with Abraham Lincoln to draft and then pass the 13th Amendment, which abolished slavery, of course. Jacob Howard also served on the Senate Joint Committee on Reconstruction, which drafted the 14th Amendment. And so, you know, he had something to say about it. In 1866, Jacob Howard clearly defined the intent of the 14th Amendment. And I quote, "Every person born within the limits of the United States and subject to their jurisdiction is by virtue of natural law and national law a citizen of the United States. This will not, of course, include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers accredited to the government of the United States, but will include every other class of persons. It settles the great question of citizenship and removes all doubt as to what persons are or are not citizens of the United States. This has long been a great desideratum in the jurisprudence and legislation of this country." So if all he meant, or all the 14th Amendment meant, was you just dropped a baby somewhere in the continental United States or any of its states, then they would have just said born within the limits of the United States. But they add this thing, and subject to their jurisdiction. And subject to their jurisdiction. So, for example, ambassadors can sometimes have diplomatic immunity, or they may be subject to certain laws in their home countries and so on, subject to that. And think of embassies, right? The embassies are considered soil of the other country and so on, right? So he says very clearly, this will not, of course, include persons born in the United States who are foreigners, who are just there for a visit, aliens, right? People who've come in illegally, and who belong to the families of ambassadors or foreign ministers, blah, 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 right? So the phrase subject to the jurisdiction thereof was designed to exclude American-born persons from automatic citizenship if their allegiance to the United States was not complete. So, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the states wherein they reside. So this is called, or could be called, the Citizenship Clause of the 14th Amendment. As I mentioned, jurisdiction does not refer to mere physical boundaries. If geographical boundaries were intended, the framers would have simply used that word limits instead of adding the word jurisdiction. Senator Lyman Trumbull, chairman of the Judiciary Committee, author of the 13th Amendment, was the one who inserted the phrase. And he said, and I quote, "The provision is that all persons born in the United States and subject to the jurisdiction thereof are citizens. That means," he says, "subject to the complete jurisdiction thereof." What do we mean by complete jurisdiction thereof? Not owing allegiance to anybody else. That is what it means. Now, we're talking 1866. Representative John Bingham of Ohio affirmed the understanding and construction used by the framers in regards to birthright and jurisdiction while speaking on civil rights of citizens in the House on March 9th, 1866. Quote, I find no fault with the introductory clause, S61 bill, which is simply declaratory of what is written in the Constitution, that every human being born within the jurisdiction of the United States of parents not owing allegiance to any foreign sovereignty is, in the language of your Constitution itself, a natural-born citizen. So, the Constitution of the United States does not grant citizenship at birth to anyone who happens to be born within the geographical borders of America. Let's say you're flying over America on your way to somewhere else. Anyway, the allegiance, complete jurisdiction of the child's birth parents at the time of birth determines the child's citizenship, not mere geographical location. For example, if the United States does not have complete jurisdiction to compel a child's parents to perform jury duty, for instance, the U.S. does not have the complete jurisdiction demanded by the 14th Amendment to make their child a citizen of the United States by birth. So if you're, let's say, a Canadian snowbird and you're down there for a couple of months in the winter, can you be compelled to perform jury duty? Well, no, because you're not subject to the complete jurisdiction of the United States. You understand, right? Well, of course, if you're in America illegally, you are still a citizen of a foreign state, right? So if you come from Mexico over the border and you're in America illegally, you are still a citizen of Mexico. You are not a citizen of the United States. You are not subject to the complete jurisdiction of the United States. So, how did this come about? You can get more of this surrounding Ann Coulter's excellent book, Adios America, but what happened? Well, 1982. See, that's how far back it goes. Was there a constitutional amendment that went through the whole process? Remember Phyllis Schlafly pushing back against the Equal Rights Amendment? Do you remember this whole conversation about? No, just created out of nothing. Automatic citizenship for anyone born in the U.S. was created by Justice William Brennan and inserted into a footnote in a 1982 Supreme Court case. You know, a footnote in a court case. Just like the founders didn't intend. So Justice Brennan slipped a footnote into a 5-4 decision in Plyer versus Doe saying that, quote, no plausible distinction, end quote, could be drawn, quote, between resident aliens whose entry into the United States was lawful and resident aliens whose entry was unlawful. I'm no lawyer. I must tell you that. You know that. I find that a little implausible. No plausible distinction can be drawn between people obeying the law and breaking the law? You know you're a judge, right? You know that's the entire point. You have one job, which is to determine what is legal and what is illegal. If you say that there's no plausible distinction between people who are obeying the law and people who are wantonly and knowingly violating the law, I guess we're going to see what's underneath those robes, because you need to take them off.
Tyler, Texas, 1975. Under the leadership of James Plyler, the Tyler Independent School District begins charging $1,000 a year for unauthorized immigrant students to attend school there. It had justified this decision by a recent Texas law that said it wouldn't use taxpayer money to educate students who were not, quote, legally admitted into the United States. Not only that, the law said school districts could deny students enrollment if their parents couldn't prove they were legal citizens. And that's exactly what the Tyler Independent School District started doing. In fact, in 1977, it began kicking kids out of school if they didn't have United States birth certificates. In response, 4 families affected by this new policy sued the school district. The district court, which, in order to protect their privacy, identified them using pseudonyms, decided that the kids should be allowed to go to school and found both the state law and the school district's policy unconstitutional. They argued the law and policy went against the 14th Amendment's Equal Protection Clause. The school district appealed, and the U.S. Court of Appeals for the Fifth Circuit agreed with the lower court. The district appealed to the Supreme Court, and the court agreed to hear the case, combining it with a similar case, weirdly called Texas v. Certain Named and Unnamed Alien Child. Anyway, the court heard oral arguments on December 1st, 1981. The court had a difficult time with this one and wouldn't announce its decision until June 15th, 1982. In a 5-4 decision, they sided with the families and struck down the Texas law that withheld funds from educating students who were illegal aliens.
If making it easy to be an illegal alien isn't enough, how about offering a reward for being an illegal immigrant? No sane country would do that, right? Guess again. If you break our laws by entering this country without permission and give birth to a child, we reward that child with U.S. citizenship and guarantee of full access to all public and social services this society provides. And that's a lot of services. Is it any wonder that 2/3 of the babies born at taxpayer expense at county-run hospitals in Los Angeles are born to illegal alien mothers?
The reason that this is a controversial issue is because nothing in the Constitution actually says that this is the case. Not only does nothing in the Constitution actually say that this is the case, there's pretty good evidence that the framers of the 14th Amendment had no intent to do anything remotely like this. Suggests that just because you come to the United States and then you have a baby here, your baby is now a United States citizen. Birthright citizenship is bad policy. I tend to agree with this. I think that birthright citizenship is bad policy. If you're just coming across the border and having a baby in the United States, that does not mean that you have come in through our legal immigration system. And your children are going to be much more impacted, obviously, by their parents than they're going to be impacted simply by force and dint of living in the United States. So if you're interested in a country that assimilates people to American values, you need people immigrating legally and then having babies here legally.
The Supreme Court has never ruled that the children of illegal aliens are American citizens. So the Supreme Court has never ruled it. Even if they did, it would be wrong. The clause speaks for itself. The author of the clause made it abundantly, unequivocally clear. And let me add one other thing. Let's read the clause together, shall we? All persons born or naturalized in the United States. Let's stop there. If it means what the proponents of birthright citizenship say, it would stop right there. All persons born or naturalized in the United States are citizens. There's no need for anything else. But that's not what it says. Then it says, and subject to the jurisdiction thereof. Now, you have some slip-and-fall lawyers, some phony constitutional lawyers. They have Esquire after their name. They come on TV. They go all over the place. Jurisdiction means geography. Jurisdiction has nothing to do with geography. Zero. It had to do with political allegiance to the United States of America. How do we know it? Because they said it. And they also excluded everybody that the left and some of the Republicans want to include.
And the like. Now, what the president is going to do is issue an executive order and wait for the Ninth Circuit or something to kick it back or say, sorry, it's no good, you can't do that. It doesn't matter. Or if, theoretically, which won't happen, but if theoretically a court were not to challenge it, it's okay. Because there's almost a presumption of correctness whenever there's any kind of an order or something done by the executive, pursuant to the unitary executive in particular. If it doesn't go to a court, nobody's objecting to it, well, keep doing it. Keep doing it. That's the way that thing works. This is an example of a fascinating subject matter of when to confer membership, citizenship, to the greatest country on the planet, with the greatest people. Maybe not the greatest government, I know for a fact. What? You hit the jackpot with this. But with that comes Congress to ask the question, do we want this? I know for a fact, in New York, Chinese citizens, people saving money, tourists coming here, pregnant women, boom. And it's not just Chinese, but as a matter of fact, and people know this. And how do you tell somebody, hey, anchor babies and jackpot babies and all this? You can't say, hey, you're coming over here for that, aren't you? No, I'm not. Yes, you are. You're pregnant. You're going to give birth any moment. That's why you're here. So there, it's something that did the drafters of the Constitution and the Congress and current iterations of Congress say, we don't care how you got here.
In 1866, they never envisioned the world in which we live in today, where we have a flood of illegal immigrants coming, mainly from our southern border. The 14th Amendment. The 14th Amendment has been interpreted 3 times by our Supreme Court to say that if you were born in the United States, even if you were here in a legal status, if your parents were here in a legal status, you're automatically entitled to citizenship. There are a lot of people who come to this country for the very purpose of having a child. Some break our law by coming across the border in our border states to go to American hospitals to have a child, so that child will become a citizen, having an anchor to the country. There are other people, rich people mainly from the Mideast and Asia, who come to America on tourist visas for the purpose of having a child in an American resort with a hospital to gain citizenship. I think those 2 ways of conferring citizenship really undermine the value of citizenship.
People were stunned to find out that this was not a settled matter. Most people believe this is etched on the bottom of the Statue of Liberty, but it's not.
Right, and I do want to give credit where credit's due to people that I learned these arguments from. John Eastman is a constitutional scholar and lawyer, litigator. He litigates constitutional questions. And Edward Erler, who's a student of the American founding and the Civil War era, who's done really the scholarly work on this. I learned this argument from them. They're 2 of my teachers. But it's true that, you know, it had kind of gone dormant for a while.
Dormant? This is Flat Earth Society stuff. So everyone believes that we have a constitutional mandate to allow the children of illegal aliens to become citizens.
And they base that belief on a misreading of the very first sentence of the 14th Amendment, which says all persons born or naturalized in the United States are citizens. They leave out the part in the middle, subject to the jurisdiction thereof. They either leave it out or they say subject to the jurisdiction just means you have to obey the law. Well, everybody has to obey the law. If you're a tourist coming from England or Canada or anywhere, you have to obey U.S. law while you're in the United States. That doesn't make your children a citizen or you a citizen. Subject to the jurisdiction meant something specific to the people who wrote the amendment. We know this because they said it. You read the debates over the amendment. They said it means that you don't owe allegiance to any foreign power, to anyone else. You're subject to the complete jurisdiction of the United States, which means you're not a citizen of another country. So it clearly doesn't apply to people who aren't citizens or who are born to people who aren't citizens, who are subject to the jurisdiction of another country. The Constitution is clear on that point. There's no statute that says otherwise. But decades ago, the executive branch agencies of the federal government just decided to apply this principle as if, well, we owe everyone birthright citizenship.
Correct me if I'm wrong, but the purpose of this amendment was to enfranchise people who had been African Americans who'd been enslaved.
Absolutely.
And so in what sense would this, I mean, does that argument even make sense?
No.
And I want to take it seriously.
As you say, though, it's the racist is just a cudgel with which to beat up people whose arguments you don't like.